Good evening, everyone. I was assigned to discuss tests and proof of negligence. I am Mr. Pepito Arazas Jr., one of the members of the Group 1. So, the tests of negligence. First, did the defendant, in doing the alleged negligent act, use the reasonable care and caution which an ordinarily prudent person would have used in the same situation? If not, then he is guilty of negligence. The law here, in effect, adopts the supposed to be supplied by the imaginary conduct of the discrete pater familias of the Roman law. The existence of negligence in a given case is not determined by the reference to the personal judgment of the actor in the situation before him. The law considers what would be reckless, blameworthy, or negligent in the man of ordinary negligence and prudence and determines liability by that. Next question. Could a prudent man, in the case under consideration, foresee harm as a result of the course actually pursued? If so, it was the duty of the actor to take precautions to guard against harm. Reasonable foresight of harm, followed by the ignoring of the suggestion born of this provision, is always necessary before the negligence can be held to exist. Conduct is said to be negligent when a prudent man in the position of the tortfeasor would have foreseen that an effect harmful to another was sufficiently probable to warrant his foregoing the conduct or guarding against its consequences. Proof of negligence. Under Section 1, Rule 131 of the Revised Rule Courts, it defines burden of proof as the duty of a party to present evidence on the facts in issue necessary to establish his claim or defenses by the amount of evidence required by law. It is up for the plaintiff to establish his cause of action or the defendant to establish his defense. In the case of Taylor versus Manila Electric Railroad, it states that, thus, if the plaintiff alleged in his complaint that he was damaged because of the negligent acts of the defendant, the plaintiff has the burden of proving such negligence. Under Section 3, Paragraph D, Rule 131, it is even presumed that a person takes ordinary care of his concerns. In Section 1, Rule 133 of the Revised Rules of Court, the quantum of proof required is preponderance of evidence. What is the presumption of negligence? The Civil Code provides for the following cases when the existence of negligence is presumed. Under Article 2184 of the Civil Code, the driver was negligent if he had been found guilty of reckless driving or violating traffic regulations at least twice within the next preceding 2 months. Has been negligent if at the time of the mishap he was violating any traffic regulation. In Article 2188 of the Civil Code, there is prima facie presumption of negligence on the part of the defendant if the death or injury results from his possession of dangerous weapons or substances, such as firearm and poison, except for possession or use thereof is indispensable in his occupation or business. It should be noted, however, that the party invoking such presumption must still establish certain preconditions before the presumption can operate. Thus, Article 2185 requires proof that there was a violation of traffic regulation, while under Article 2188, it requires proof of possession of dangerous weapons or substances. The res Ipsa Loquitor, its function is to aid the plaintiff in proving the elements of a negligence case by circumstantial evidence. The res Ipsa Loquitor doctrine is based in part upon the theory that the defendant in charge of the instrumentality which causes the injury either knows the cause of the accident or has the best opportunity of ascertaining it, and the plaintiff has no knowledge, and therefore is compelled to allege negligence in general term and to rely upon the proof of the happening of the accident in order to establish negligence. The inference which the doctrine permits is grounded upon the fact that the chief evidence of the true cause, whether culpable or innocent, is practically accessible to the defendant but inaccessible to the injured person. In the case of Sugar Central Company Incorporated versus Honorable Court of Appeals, it quotes, where the thing which causes injury is shown to be under the management of the defendant, and the accident is such as in the ordinary course of things, does not happen if those who have the management of the defendant, and the accident is such as in the ordinary course of things, does not happen if those who have the management use proper care. It affords reasonable evidence. In the absence of an explanation by the defendant, the accident arose from want of care. The following are the requisites in the application of the doctrine. Number 1, the accident is of a kind which ordinarily does not occur in the absence of someone's negligence. Number 2, it is caused by the instrumentality within the exclusive control of the defendant or defendants. And number 3, the possibility of contributing conduct which would make the plaintiff responsible is eliminated. In the requisites mentioned, the fundamental element is the control of the instrumentality, which caused the damage. Such element of control must be shown to be within the dominion of the defendant. In order to have the benefit of the rule, a plaintiff, in addition to proving injury or damage, must show a situation where it is applicable and must establish that the essential elements of the doctrine were present in a particular incident. Here are the elements of res ipsa loquitur. Number 1, the accident is of such character as to warrant an inference that it would not have happened except for the defendant's negligence. Number 2, the accident must have been caused by an agency or instrumentality within the exclusive management or control of the person charged with the negligence complained of. And number 3, the defendant must not have been due to any voluntary action or contribution on the part of the person injured. Here are some recent jurisprudence that we can discuss. In Harsha versus People, the doctrine of res ipsa loquitur as a rule of evidence is unusual to the law of negligence, which recognizes the prima facie negligence may be established without direct proof and furnishes a substitute for specific proof of negligence. The doctrine, however, is not a rule of substantive law, but merely a mode of proof or a mere procedural convenience. The rule, when applicable to the facts and circumstances of a given case, is not meant and does not dispense with the requirement of proof of culpable negligence on the party charged. It merely determines and regulates what shall be prima facie evidence thereof and helps the plaintiff in proving a breach of duty. The doctrine can be invoked when and only when, under the circumstances involved, direct evidence is absolute and not readily available. Negligence is defined as the failure to observe for the protection of the interest of another person that degree of care, precaution, and vigilance the circumstances justly demand whereby such other person suffers injury. Reckless imprudence consists of voluntary doing or failing to do without malice, an act from which material damage results by reason of an inexcusable lack of precaution on the part of the person performing or failing to perform such act. In failing to perform an extensive medical examination to determine the extent of Roy's injuries, Dr. Harsha and Dr. Bastan were remiss of their duties as members of the medical profession, assuming for the sake of argument that they did not have the capacity to make such thorough evaluation at that stage. They should have referred the patient to another doctor with sufficient training and experience instead of assuring him and his mother that everything was alright. In the case of Eddie Cortel, E. Carna, and Yellow Bus Line Incorporated versus Cecil Gipaya Lim, the res ipsa loquitur doctrine is based in part upon the theory that the defendant in charge of the instrumentality which causes the injury either knows the cause of the accident or has the best opportunity of ascertaining it, and that the plaintiff has no such knowledge and therefore is compelled to allege negligence in general terms and to rely upon the proof of the happening of the accident in order to establish negligence. The inference which the doctrine permits is grounded upon the fact that the chief evidence of the true cause, whether culpable or innocent, is practically accessible to the defendant but inaccessible to the injured person. The elements of res Espaloquitur: 1. The accident is of such character as to warrant an inference that it would not have happened except for the defendant's negligence. 2. The accident must have been caused by an agency or instrumentality within the exclusive management or control of the person charged with the negligence complained of. And the last one, number 3, the accident must not have been due to any voluntary action or contribution on the part of the person injured. In this case, Cortel had exclusive control of the bus, including its speed. The bus and the motorcycle were running in the same traffic direction, and as such, the collision would not have happened without the negligence on the part of Cortel. It was established that the collision between the bus and the motorcycle caused Lim's death, aside from bare allegations that petitioners failed to prove. There was nothing to show that Lim had contributory negligence to the accident. The rule is when an employee causes damage to his own negligence while performing his own duties, there arises a presumption that his employer is negligent. This presumption can be rebutted only by proof of observance by the employer of diligence of a good father of a family in the selection and supervision of its employees. In this case, we agree with the trial court and the Court of Appeals that Yellow Bus Line failed to prove that it exercised due diligence of a good father of a family in the selection and supervision of its employees. Cortel's certificates of attendance to seminars, which Yellow Bus Line did not even present as evidence in the trial court, are not enough to prove otherwise. The inapplicability of this doctrine. First, it is not applicable if there is direct proof of absence or presence of negligence. As early as 1910, the Supreme Court already explained that the doctrine merely creates prima facie case and applies only in the absence of proof of the circumstances under which the act complained of was performed. It is something invoked in favor of the plaintiff in the absence of proof. If there is sufficient proof showing the conditions and circumstances under which the injury occurred, the creative reason for the doctrine of res Ipsa Loquitor disappears. This was highlighted in the case of Martinez versus William Van Berker. It is also inapplicable if other causes, including the conduct of the plaintiff and third persons, are not sufficiently eliminated by evidence. It is not applicable when an explained accident may be attributed to one of several causes, for some of which the defendant could not be responsible. Under the case of FGU Insurance Corporation versus GP Sarmiento Trucking Corporation,